International Court of Justice dealt with extraterritorial, accepts extraterritorial application of human rights law in the whole case, Uganda case. It speaks about lex specialis in the nuclear weapons and the war case, but it does not really apply lex specialis. It has a cumulative approach. It cumulates the two, but it has not yet led to absurd results. The European Court of Human Rights has had a lot of problems with the extraterritorial application. It moved from Bankovic, no extraterritorial application, to today, territorial control and personal control. As for IHL, traditionally in the cases concerning Turkey and Chechnya, it's simply ignored IHL, but used, at least in English, not in French, they didn't understand the translator, they copy-pasted wording from Protocol Additional 1 on precautionary measures. But now, with Hassan, I think we have a tendency where they actually take into account and accommodate. Now we have future cases, Georgia versus Russia, Ukraine versus Russia, where the European Court will have to deal a lot with IHL. I think the toughest point on the right to life remains the absolute obligation of inquiry they see, which does not exist in IHL and is very difficult in hostilities to imagine. The inter-American system is very open, extraterritorial, much larger. It applies human rights in non-international armed conflicts. The Commission was going further. The court was slowing down in the Las Palmeras, Bamaka, Velázquez case. It uses the term lex specialis. It uses IHL to interpret and reinforce human rights law, in particular on disappearances, on destructions, on pillage, on the rights of women and children. A very interesting thing is now on reparation, and a lot of people don't know that the Inter-American Court has decided, following some massacres, that states have to make dissemination of humanitarian law and of human rights law, and they have to adopt national legislation of implementation of both humanitarian law and human rights law as a reparation, and all public officials must know the Inter-American Convention as interpreted by the court, and the court introduces humanitarian law. This is an interesting aspect of prevention. And finally, the African Commission and Court. The convention applies the African Convention on Human and People's Rights applies in non-international armed conflicts. The only case where it dealt really with IHL was in Democratic Republic of Congo versus Burundi, Rwanda, and Uganda. There it said that the Commission is entitled to take IHL into account, that the Geneva Conventions and additional protocols are general principles of law recognized by African states. It referred very liberally, and not always totally accurately in my view, but to IHL, but only always in link with a provision of the African Charter. And in its reports and examining reports, it does interestingly not mention, even where there's an armed conflict, international humanitarian law. Please.
With that, very quickly on UN Human Rights Committee working group on arbitrary detention that recently published documents that are relevant to the issues that we are discussing. UN Human Rights Committee General Comment number 35 on Article 9 of the ICCPR, liberty and security of the person. And there, it's interesting to note that it recognized that security detention, namely internment, that is authorized and regulated by and complying with IHL, in principle is not arbitrary. So, in essence, this goes for IHL internment provisions in international armed conflict, because only there you have both authorization, regulation, etc. So in essence it leaves out non-international armed conflicts, and then it also deals with the issues of limits of derogation. Here again, in terms of international armed conflicts, it says that the substantive and procedural rules of IHL remain applicable and limit the ability to derogate, so such that this is sort of the minimum kind of standard that you would still have to comply even when derogating. Here again, a distinction to non-international armed conflicts. With regard to the working group on arbitrary detention, here there are certain principles that are specified even for international armed conflicts, such as appeal or periodic review of decisions to intern, applying in an IAC, that these must comply with principles including habeas corpus. So it is not entirely clear if they had in mind really to draft, additional recommendations, because on the face of it, of course, there is a challenge already with some of the rules that are contained in the third and the fourth Geneva Conventions. In non-international armed conflict, so in essence, administrative detention or internment only possible if there is a public emergency and the extent and complying with the requirements in terms of derogations. So there is a need to derogate if in non-international armed conflicts if you want to resort to this possibility. I just quickly wanted to also say a few words on two special rapporteurs that recently have conducted some work interesting for some of the issues, namely the special rapporteur on the right to life, so summary and arbitrary executions, Chris Haynes, who took a specific interest both on the use of force in general, obviously, including for law enforcement, but also in the context of lethal autonomous weapons and armed drones. In this context, I mean, there was quite a realistic recognition by Haynes that although human rights continues to apply, he recognized that conditions under human rights might be relaxed in the light of IHL also applying. So that was quite interesting to note. And also with regard, because it has been touched upon, issues in relation to investigations after the fact. This is one point I forgot perhaps to mention, that this is still an issue where it really matters if you have for instance, a law enforcement operation or an operation under the paradigm of conduct of hostilities, because simply the thresholds, especially when an obligation to investigate is triggered, as well as in which circumstances are simply different under human rights and IHL, so human rights much more stringent, of course. And here he also recognized that in armed conflict situations, the stringent requirements under human rights might be considered to be attenuated. That in distinction to the Special Rapporteur on Counter-Terrorism, where the Special Rapporteur in terms of investigations applied quite a strict standard. That there is an obligation to investigate under both bodies of law every time there are unintended or unanticipated civilian casualties. So that would then trigger an obligations to investigate. And of two components, so first conduct fact-finding, and then if there's a reasonable suspicion of violations, then criminal investigations.